क्यों डरे कि जिंदगी में क्या होगा, हर वक्त क्यों सोचे कि बुरा होगा। बढ़ते रहे बस मंजिलों की ओर, बढ़ते रहें बस मंजिलों की ओर। हमें कुछ मिले या ना मिले, तजुर्बा तो नया होगा। With this, I welcome our esteemed guests who have not only joined us from India but also from Thailand and all the viewers watching us live today. I'm blessed to introduce you to our esteemed speakers who have vast experience in the legal industry. So we have Ms. Vinati Gupta, Associate General Counsel, Southeast Asia, Aditya Birla Group. The name has a lot achieved in the industry and has vast experience working with companies like Wipro Limited and firms like Gupta. She specializes in contract drafting and negotiation, M&A, due diligence, corporate advisory on areas including competition law, property law, financing, and IT, among others. Thank you, ma'am, for joining with us today.
Hi, Sahil. Thank you so much for the introduction.
Thank you, ma'am. Nonetheless, when a general counsel is on the screen, how not to get the insights from a practicing legal professional. And with this, we have Minal Madan, experienced transactional lawyer with a demonstrated history of working with the top law firms in the legal industry, skilled in corporate law, merger and acquisition, private equity and venture capital, intellectual property, and corporate governance. I welcome you, Minal.
Hi, Sahil. Thanks for having us.
Thank you so much, ma'am. Now I would request Rishwan to please take over the screen and start the discussion.
Thanks a lot, Sahil, for that wonderful introduction. Hi, Minal ma'am. Hi, Vinti ma'am. How are you doing?
Hi, Rishwan. We're good.
Great.
Thank you.
Great,
Looking
great,
good
great.
for you.
All well, yes, absolutely. Thanks a lot. Welcome all the audience joining us on various platforms live. Thanks a lot for tuning in on a Saturday afternoon. It's a cold, cold afternoon here in Delhi, at least. Um, yeah. Today's session is very interesting and something of personal interest to me because I like all things tech, especially consumer tech. So data privacy and data protection and all of these things are something that go hand in hand with the development of technology in and around the world. So this is now the legal world catching up to how far the technology has been going in. And considering the kind of audience that we have today, we have some brilliant, brilliant speakers with us discussing exactly how India is dealing with the progression of the technology, primarily relating to data protection in light of the PDP bill of 2019. So the idea behind this session is to give an overview to the audience and also discuss certain technicalities with Vinti ma'am and Meenal ma'am, give you insights on things that you may not know, and also give you perspectives to think about once you're done with this session and enjoy the Saturday evening with your family. With that, I will be starting with the very first question. This one is for Vinti ma'am. Ma'am, could you please help us understand what exactly is data protection? I mean, there is a ton of data, and this word has suddenly become a buzzword in the past year, year and a half. But for those who've not really been started on this already, could you please help us exactly understand what is data privacy or data protection from a legal perspective?
Right. So the first information on data actually is contained in the IT Act itself. But now that we're talking about the PDPA, your personal data, it basically means anything which allows you to be identified as a person, right? So there's a lot of data now which is available even electronically, online, etc. And so data protection has become a buzzword because there are two inherent things which are involved in it. One is obviously your individuality, which is covered under your right of privacy. But there is a second aspect also, which we are, moving more towards digitalization, artificial intelligence, etc. There is a monetization, or which is associated with your personal data, which means that your identity, your habits, your online browsing, the way data is processed, that can actually be utilized by businesses which can target advertisements, products, content to you, right? Which is why it has become much of a buzzword today. So aspects, one is the right of privacy to it, and second is the there is basically your data is to be recognized as a resource, right, which can be monetized, which has an economic value associated with it. And without any law being there in place, there are people who are gaining access to it and processing it to obtain wrongful gains. So that is the whole context of why we are discussing so much about personal data right now.
Interesting. That's an interesting insight, ma'am. Also, before we proceed further, there is one disclaimer I had for the audience. Whatever kind of views are being discussed today are entirely the personal views of the panelists, and these do not reflect the views of the associations or the companies that they represent here today, because personally, they're here representing only themselves right now. So that must be kept in mind. Moving on to Minal, ma'am. Ma'am, how would you look at data protection and what it means for the legal industry?
Sure. Just to give you an idea of what it means to protect data, let's first understand the impact that data has on us in this world. And the biggest impact that we have seen is that in the recent past, the world has moved online. Whatever we used to have physical documentation and all, the world has completely moved online. And right from, how Vinati said, simple things on an everyday basis that we can recognize is things like cookies on our Google browser. It remembers your passwords, it remembers your history, it remembers what you have searched for. Because if I today search for X on Google, basis that X, I'm given a recommendation of a Y. Now, how does this happen? This happens is because the data that we do give the information for a simple search is processed in form and manner that it is utilized and has an end goal for the company. Now, that end goal can be anything. Now, as a customer or as an individual, the biggest issue is education. The person not being able to understand what is this right that first of all is being restricted. It's not about being given, right? It's about the fact that if I go on Facebook, LinkedIn, or any other most popular platform today, there are rules and regulations on how can I restrict my account. So in a way, there is a restriction on the freedom that I have. Because if I do not go to Facebook, that restriction does not apply to me really, does it? Do I need to have close friends? Do I need to have be able to see who is able to see it, who's able to block it?
Right.
These small steps, these small things, every simple control that has been provided to us is a step towards data protection, simply because our freedom is being regulated, our privacy, the data that we share, the thoughts that we have, they are being not only regulated, they are being processed by third parties that not only do we know about, but we have no way of knowing how it is being used for us.
Correct.
Now, most important about these things becomes something as simple as your banking information. If you are looking to open up a new account, does that entitle a third company to give you a cold call for a credit card or for opening an account with a particular X bank? It's the reach of the data, how it travels, and considering we do not know the route it takes, it's only fair, for the individuals or for corporations to understand where are the lines drawn. And to understand what we have to protect, we first have to educate the customer or the consumer to understand where is it that their right is being affected. For that, we have to understand from the corporates, what is the end goal? Is it monetization? Is it exploitation? Is it sale of a side product? Because there are multiple combinations that can be used. So the reason this bill has become as you say, buzzword, and the reason we need to protect is because we don't know the extent of exposure that's out there.
Right. I will, in fact, circle back to you with regards to education once we've had a look at PDP and discussed a bit about it. But in the meantime, so data is not new, right? I mean, there are entire business models of big tech giants which uh, have their businesses running only because they collect user data and they turn it around, and then they either serve you advertisements or they serve you products which they feel are something of interest to you, right? So this entire issue may be new, but the practice of the industry is not something absolutely new. So, Minal, how has been the domain regulated so far? PDP is a very recent development, right? So, did we already have laws in place before this, which probably largely dealt with the topic?
Okay, so going back to that, as you would know, the right to privacy was upheld by the Supreme Court in very recent past.
Yeah.
The problem that I see in this whole data protection and the business around data was the fact that the industry grew so fast that things that became practices were taken into consideration because there was no one to oppose it at the time. And as you know, law is always there catching up. That reason being that there are incidences that you cannot control. So, as far as controlling the domain was considered, whatever laws were in place at the time were already regulating the companies as far as Companies Act are concerned, as far as tax returns are concerned, to see the finances, as far as your filings are concerned, if it's a listed entity, if it's an unlisted entity, the government does have procedures in place. Those same procedures which were being used for ages and ages were expanding its roles to understand what is happening there. Because those regulations pointed out the issue, which is why there was a need felt to have a regulation like PDP in place. So while I understand people may say, how was it, regulated before or even now, considering the PDP is not in place? But that does not mean that we do not have other laws in place. There's the information technology law. There are, various ways these data are exploited. Where does all of it go? At the end of the day, if there's no financial gain, let's face it, no one's going to take the risk. So
Right.
if you follow the money and if you follow the law, it will lead you to the right place. That's what I believe.
That's a very interesting way to look at it. That's super, super insightful. Vinti ma'am, could you please shed some light on how other domains have been dealing with this issue in the past? I mean, I'm not talking about the new age data protection bills or regulations that they have in place, but say the slightly age-old laws that they had. Did some of them already have decent measures in place, foreseeing that an issue like this might pop up?
Yes, you're right. All of this is already contained in the previous laws, but like Minal rightly pointed out, that we were always following up with what had already happened, right? So, phishing scams has been pretty old, and there are banking regulations. So, in fact, you can very easily bifurcate the laws which are already there in the domain. One is obviously your constitutional right. Your right to privacy, which is a part of your freedom of life and liberty. Second is obviously the IT Act, which has also coped up with it. So you see handling of sensitive personal data under 43A, and you see that it requires the person who's holding or collecting the information to actually have reasonable security measures in place and make sure that the data does not get leaked by acts of negligence or by just treating data casually. Then you also have 72A, which basically prevents anybody else from gaining wrongful gains from your data, right? So in fact, if you think about it, like when we were kids, when you had railway sheets pasted on the couch, right? So it actually had the PAN card details of all the passengers. So we so much wanted to avoid a conflict. We wanted to be so clear about who that berth belonged to, that there were people actually noting down those PAN card details, and those kind of scams have been there, right? So that's why the banking regulations. So the third category is the sectoral laws. So there is banking regulation. If it is a medical related thing, so then there are regulations for that. If it is an insurance related thing, there are regulators. You have privileged communications between yourself and the doctor. You have privileged communication between yourself and the lawyer. So as such, privacy and this data protection has always been there. But then why do we need this now? Okay. So again, like I said, that because of artificial intelligence, now every online activity is monitored, it's processed, and it is used to feed information to you. It is used to feed information to you, which can actually not be news. It might be misinforming you, right? And being well informed about what's happening is actually a very, very, very important part of your democracy. But if these online activities, so if let's say I just click some link about some news which is like a half baked opinion, right? So artificial intelligence allow that particular media, that platform, to keep throwing those kind of suggestions to me as something I may like, and therefore my opinion, my understanding of what is actually happening in the country or the world around may be absolutely off the mark, right? So the reason why data privacy bills have become so important now is because this misinformation, the spread of misinformation, needs to be stopped. And that, I feel, is the primary reason why there was a need felt to consolidate this. So in fact, we all are aware, I mean, I don't know if there are actual proofs or not, but this misinformation actually caused an impact on the 2016 elections of US. And after that, EU was the first one to come out with a comprehensive GDPR regime, which actually takes care of your processing, right? So that is why law has caught up. And if you want to look at it, you have to look at how the data is being collected. So there are three ways of collecting data, actually. One is by direct consent, which is absolutely easy, straightforward. If I need certain functionality from a particular application or something, I need to give consent, right? Second is indirect. So basically, you are not seeking my consent for running background applications, the cookies bit, which Minal mentioned. And then there are also partnered sites where there is funding coming from, and then for various reasons, it could be advertising, it could be to support a particular political view, we do not know. So that is indirect tracking. And third is by acquisition of data which is already available, right? Now, if you look at the entire, whether you look at GDPR regime or you look at the PDP bill or anywhere around the world, what it's trying to do is that it only allows you take proper consent, right? Proper consent means that you have to tell people what you're using it for and how it will be used. It can, and if there is misinformation, you cannot have a clear consent, right? Your so basic the tenet of consent is basically void there, right? So you have consent, or second, you use it in a anonymized or a pseudonymized form so that nothing can be traced back to you, right? So with this, what the regulators are to do is that you are removing this entire layer which was never coming in forefront.
Vinti ma'am. Minal ma'am, would you like to take over in the meantime? I think there is some connection issues that we're facing with ma'am.
Yeah, I think she had a point of view that she wanted to say. I will shift to a very different point that I had in my head while I was working and listening to Vinati. See, most of my transactions that I've worked on have been M&A investments and transactions, right? Now, in these transactions, what happens, right? You see a big basket, you see a Swiggy, you see a Zomato, you see an OYO. Everyone has investors. Now, where are these investors? These investors come from all over the world.
Right.
And at the same time, while they are a part of the company, they also have the access to the data that the company is processing, which gives them an idea of how a country is performing or how the market in a particular sector is performing. So when that happens, there were other issues in relation to data protection that were raised. Issues regarding where is the data going? Where is the data being stored? Who is able to use it? What are the restrictions on the usage of data? Because the layer starts from an individual, but as in any other profession, or in any other practice, it goes to a corporate level, then it goes to a country level. And if the individual information is taken to a macro level,
Right.
wherein the entire statistics of a country can be determined from the data that is shared, it becomes very dangerous as to what is the data that is with the right people and is it identifiable. Because today, honestly, if there is, let's say, someone who's identifiable and who is a normal person doing about the normal job, it is a very different matter. But if the prime minister of a country is identifiable basis the Google search he has or the accounts he maintains, it's actually a direct threat to the country, right?
Right.
So it depends on how you see the issue. At a micro level, the issue will be as small as micro it is. At a macro level, it will blow up to affect countries, international politics. So the issue has taken so many views and so many facets that one really has to sit back and think. Now, when the Facebook investment happened in Geo, that was really between COVID times, right? One would see
Yes.
that as one of the biggest data transactions because Facebook is one of the biggest data market in the US and Geo has the biggest data market in India.
In India.
Now, that was not a simple transaction. A transaction like this could not have been imagined, let's say, 10 years before. But today, because data is gold, data is what's mined, it was a transaction on data.
Mhm.
So the reason this bill is required and the reason this bill was a separate need was because at an individual level, people were being affected. But at a macro level also, there was a major effect which could change politics, which
Right.
could change politicians, and which could determine, the country's future and who's actually behind it, who's managing it, or who's controlling it, who's leading it.
Right.
So it also goes against the principles of constitution, principles of freedom. It goes also against principles like democracy versus other dictatorship or any other kind of country
Governance.
governance that they might have.
Right.
So considering the issues are at such different levels at the same time, and it's all being affected by this one aspect of data,
Right.
it is very important for people to understand, as Vinati said, what is it that we are giving consent to? Has consent been taken? Is the information that has been provided processable? If it is processable, then can the person or the individual or the company be identified? If they are identified, then to what extent that identification exists? And if that all limits have been crossed or all consents have been given, then is the data being used for the benefit of a country or a corporation? That is very different from
Right.
using it for financial gains or using it to sell a side product or to even affect the elections outcome.
Absolutely.
And that power of a democracy lies within the people, right? Now, if that power of a democracy is taken away from the people that choose their representative government, at the end of the day, the basic principle of democracy is also affected. So it
Correct.
has a very large effect. It has a trickle down effect also, which is why earlier I said that education and educating the people about what data is, how it can impact, what consent means. That I think is the biggest challenge and also the biggest benefit.
That makes a lot of sense. Vinti ma'am, I think you dropped in between, and that is why we continued with the session with Minal ma'am. Would you like to finish off the point that you were discussing with regards to collection of data of individuals and cookies?
No, I think whatever I started off, Minal completed it rather well, because that was exactly my point, that if you are not properly informed, you cannot give a valid consent, and it impacts you not in terms of privacy, it impacts you not economically, but it impacts the entire country. And a country as populous as India needs to understand the power that people has in dictating the future course. So
That's very powerful. Uh, but so at the end of the day, the bill is going to be applicable to the masses, right? It's the people who the bill will be governing and how their data is collected, etc., etc. And the bill will only be as effective as it is able to really, go down to the roots and manage things properly right from the source of collection. So on a day-to-day basis, once the PDP is in fact put into place, how is the daily lives of people who are surfing the web, say, looking at news or downloading media or just googling things up, as we popularly say, how is that going to be changed?
So when it comes to individuals, I think it really depends on their understanding of what is okay to give consent to and what is not, right? So when it comes to individuals, obviously they'll see a lot of pop-ups. Now either they may choose to ignore when you are asked for consent because you are in a hurry to access some website or go online, or
Right.
actually involve yourself better, try to figure out what is the kind of consent you want to give. For individuals also, we hold a lot of our data on our handheld devices now, on our
Correct.
laptops, on our mobiles, which is everything, all our identity related documents to all the finance related documents, our emails, pretty much everything. So I think the first thing is that individuals have to understand what they can say okay to, what they do not want to say okay to. And at the end of the day, it's going to be like a cost benefit analysis, right? Because just a few weeks back, I was accessing some site, and the site actually gave a notice that we rely on advertisers to fund the site.
Mhm.
You give us permission to share your information with the advertiser, or you subscribe to our services, right? So I'm seeing that kind of innovative sort of disclaimers or notification from the websites now, that you make an informed decision. Do you want us to take your data, or do you want us to do you want to pay us and subscribe for our services, right? So that is how I feel individuals will be impacted under this.
And what about the businesses? So, companies that are operating in India or companies that are collecting data of Indians, because that, if I'm not wrong, is one of the applications and applicabilities of the PDP bill. How is that going to change their businesses, or rather, how they operate probably?
So, if you look at the cost of compliance, obviously, cost of compliance is going to go up, right? What this bill provides for is a privacy by design, which means every single step has to be in a way that you can protect the privacy. You take consent from your data principals. You give them a right to be forgotten. You only use it for the purpose that you have received. You have to be extremely transparent, and they can ask you for information reports on how it has been used. If you have already utilized it for the purpose for which it was given, it has to be erased. There is a timeline. You have to have organizational security, like encryption related. You have to have everything in your processes. So
Right.
cost of compliances, yes, it will go up. But it's something that I think most of the businesses were already anticipating the moment GDPR came into place.
Correct. So some of them have, in fact, even started doing it, like you just said. And in my personal experience, couple of journalism websites, they're very, very clear about the fact that journalism, of course, is not free, and this is how we earn our bread and butter. So either
Yeah.
you pay us for what you read, or we will have somebody else pay us to generate the content. But of course, we need to get paid. So, but
Yeah.
this is the first time that such disclaimers are being put up. So that's very nice and interesting to see. Minal ma'am, how does your job as a lawyer change once the PDP does kick in? What do you think will be the first steps when, say, a company comes to you or a client comes to you and says that we know that the PDP is now in force, but how do we become compliant? So, how does your job as the lawyer change now?
So I think it will be very interesting, considering it'll be a job where, I think we'll be most probably interpreting, once the PDP is in place, we'll be interpreting what is the intent of the legislators when they were drafting. And, then to sit with companies and actually understand the issues they face. Because let's understand, when there's something new in place, it's not about how you understand it and how you implement it. What's more important is these days, every company also knows that, if you're doing best in industry practice, it really matters, getting in businesses, being in top of the line, X and Y and that. And any new law that comes into place needs to be understood with the industry that it's going to be applicable to. So I think there'll be a lot of back and forth with the industry. We'll be sitting down, we'll be understanding the issues, and at the same time, understanding the limitations of law. And I think it'll be a very interesting path of, sort of carving out, the mid path between, to understand the restrictions and limitations, and then to set in place the standards. The most important thing as lawyers that we will be doing is not only will we be bringing the legislation and the industry's interpretation together, but then
Right.
we will have to actually give companies certain standards that they will have to keep in place to make sure there's compliance with law, while there's no restriction in business that they're doing. So setting that standard, I think, is something which will be very different for every company. It'll be basis the industry, it'll be basis their, the customers that they have, how do they process data.
Right.
So I think it'll be a very hands-on job, and it'll be something where, the client will benefit the most, because once you sit down and put your brains together, you get one of the most efficient solutions out there. And in law, I think that's something that's that's required. And considering also, being a common law country, there will be no precedents. It will literally be the lawyer's job, to think forward for their clients and make sure that while they're, interpreting the law, they're not making any sort of detriment to the business, but at the same time, you don't also want your client to go to the court. So it'll be quite interesting and challenging, but at the same time, it will give us, the industry to have a discussion and then come up with a practical solution.
So
That is, I think, something very exciting.
Right. This reminds me of this basic understanding, which I think most lawyers in the corporate side, and please correct me if I'm wrong, both Minal ma'am and Vinati ma'am, you're way too senior for me. The fact that, good corporate lawyer also needs to have some basic understanding of finances. Like, you need to know how balance sheets work, and you need to understand and read them, and see how the business models of the companies are functioning. So now, once the PDP does get kicked in, these same lawyers will also now have to start understanding the absolute basics of some technical concepts also, how data is probably collected and how it is processed and what data centers are. So that will also be a nice interesting challenge. Meena ma'am, getting back to the one point that you said about the industry having a little bit of a back and forth. The industry having a little bit of a back and forth between the regulators and the legislative intent behind this entire thing. Does this remind you of the IBC of 2016? Because 5 years, about 4-5 years down the line, I think we're still at a junction where almost on a weekly basis we're having some or the other new precedent coming in about with regards to the IBC, and regulators are still trying to figure out how what part operates. Do you think we're going to have a repeat of the same, or do you think this is going to take a slightly different route?
I think we might have a repeat of the same, simply because there seems to be a precedent, right? And these days, regulators are also of the view that they want the rules and the regulations to be implemented, and to be implemented in the way that does serve the purpose of the draft that they had made. And in relation to that, it's very important, because the regulators are there to make the rules, but they are not the ones to whom the rule is actually being implemented, right?
Correct.
It's a simple case of someone making a rule versus someone being enforced to follow that rule. And the person who's facing that challenge, those challenges need to be communicated, and that is what leads to a better law, or sort of a better space where companies can grow. And in an environment wherein there is growth in business and in industry, and for that to happen, the legislators and the industry has to have some sort of exchange, because if they cannot understand each other's negatives or positives, then who's going to suffer at the end of the day? The cost is going to be on the company. The regulators will always be heavy with work. Where are the companies going to get the cost from? The end cost is always to the end customer.
Yes,
Right?
it will be passed
So
on.
the more efficient the business environment is, and more efficient, the legal system is, and the better, it can be solved by having clear-cut pictures. And here we are talking about transparency, right? In data protection bill, transparency is one of the main things. So if all that exists, it gives a very good environment for business growth. And considering Modi's objective is also to bring businesses and growth in India, I think it quite is in line with setting the IBC precedent also, and having a full-on discussion. Even when the Companies Act 2013 came, there were a lot of industry comments that came that only helped understand how it will be implemented. And
Right.
there were a lot of deadlines delayed. There were a lot of filings which were changed. That basically means that law is keeping up with the times.
Correct.
And considering that we have been a country where we have been criticized time and again for laws being behind its times,
Yes.
I think it's a good thing that we are living up with the times. We are catching up, so it should be welcome.
Absolutely. In fact, you're absolutely right. Even right now, the PDP is still being deliberated by the parliament. There is an entire JPC which has been formed. They're still doing industry consultation. So that is a very heartening thing to see, that a major legislation which is going to probably really change the course of a lot of businesses in India is being developed by the legislation together with the industry, keeping their interests also in mind. That's very good, very motivating. Vinati ma'am, I would like to pose the same question to you, albeit in a different form. This is how the PDP in India is being formed. We were just having that little chat about how regulators in Thailand function. Could you please help the audience also understand exactly how the same thing, if it were being done in other jurisdictions, including Thailand, how does the industry respond to such kind of a development, and how do the regulators really get down to implementing these laws?
Yeah, Rishwan. So in Thailand, generally, there is a lot of participation that you have to do at every level with the regulators, right? Now, the Personal Data Protection Act, while it has already been passed, but it is yet to come in force. So we are expecting that to happen in June 2021. It was supposed to happen in May 2020, but then in light of COVID, it was deferred.
Right.
And a lot of issues in the law itself where we are not able to understand how the law is supposed to interplay with the other laws, right? So for instance, there are certain laws which require you to maintain certain records, and you have certain authorities which can ask you for it. But the Thai law, it does not really specifies anything, like how your Indian PDP bill says that, wherever there is a legitimate requirement under the law, you have to, that sort of overrides your form. Thai law does not, it recognizes the fact that you are supposed to legally do it, but it does not really say in as many words, right? So that is one place where we will have to work with the regulators and understand how this is going to work. The second thing which I see in the PDP bill is that it actually bifurcates the data into what is your employee data, and you need it for the benefit of your employees, or to work out their salary structures, their promotions, their transfers, their their career progression, etc., vis-a-vis what is a third-party data, which could be, considering you're not a Google or a Facebook or another techie, if you're a regular, company, so it could be third-party data, which could be your customers, which could be your suppliers, etc. So how you can actually utilize that data? Can you do this? So there is a bifurcation in the law, right? So employee data you probably can to a large extent, but for customer data, for supplier data, and for any other data, you have to go through the rigorous consent norms which are there. All the right to be forgotten, etc., is applicable in the same way, right? But in Thailand, it is not really differentiated into these different buckets, that this is okay. So the law is not very explicit in terms of what you can do, what you cannot do, and therefore interacting and dealing with the regulator on a regular basis gonna be very, very critical to implement this effectively.
Right. So the only difference I see is that in Thailand, probably this is how almost every new legislation is implemented, and this is one of the rarities in India that we're seeing that some new thing is being done in consultation with the industry. But I think it's for the benefit of everybody that this is how it is being done. Vinati ma'am, could you also please shed some light on what are some of the key features that a majority of these data protection legislation from across the globe talk about and deal with, so that we can also then examine if the Indian PDP also talks about it, or if there are any lacunas that they need to bring into picture.
Okay, so I think the very first thing that the legislations all across the globe they talk about is the consent. Now, Indian PDP bill has gone, let's say, a level further to say that your consent cannot be collected in a very mechanical form, right? If somebody is giving you the consent, you have to make sure that they understand it, right? So, which means if you see the way social media is being used, if they do not understand English, you may have to also provide the consent form in their local language as well. So consent and the Indian PDP bill actually makes a very robust mechanism of consent, which also includes your right to be forgotten. Right now, if I again come to GDPR, there are no timelines per se, and the time for which you can actually hold the data can be extended. Whereas your Indian bill clearly says that only till it is required for the purpose, whatever is reasonable time, you can retain the data, after which you have to erase the data, right? The second part, which is like a salient feature of this bill, is it governs how data is going to be processed, right? So we've discussed earlier that you have had all these rights beforehand, but there was no corresponding duty on your service providers or on the people who are now classified as data fiduciary or data processors under the bill. But right. This actually imposes that duty, which means that you have to take certain measures to make sure that your collection of data, your storage of data, your transfer of data, your processing of data, everything is in line with what the law requires you to do, right? So that's going to be the second thing. Third thing, which I see PDP bill offering, is it actually gives more right to the data principle with respect to the data, right? So right to be forgotten has been recognized, and it's the same as GDPR, right?
Right.
But then Indian people has gone one step further, which says that if you have chosen your right, if you have exercised your right to be forgotten, going forward, whatever is the consequence of such exercise of such right, that has to be borne by the data principle, right? So it's not like an unreasonable burden on the data fiduciary and the data processing. Then fourth, PDP says is that if there is a data processor, he cannot further subcontract the part of processing to another data processor, right? And this stems from the fact that if I think we will all be aware that the applicability is in India, and what happens if the data breach happens and the data reaches out of the country. So correct. Right, so these jurisdictional issues have always been there with the IT Act also. So one of the key things which I see PDP bill addresses is that it will not allow data to get onto another server where it will not have any control whatsoever, which is why the localization of data requirements have also been entered in, which are rather controversial for other reasons. But I think that is the purpose why the bill has really harped onto the localization bit. And then we look into what are the remedies which are available in case there is a breach, right? So that way, again, when I look at the PDP bill, it also talks about it basically categorizes the kind of breaches which are there. And based on the breach, there is what is the scale of the breach, what is the possible harm of the breach, and based on that there is also a credit score which is given to the data fiduciary, right? So somewhere, without actually incorporating the elements of compounding of these kind of breaches and offenses, that has been included rather tacitly, but it can be done. Then another thing which I see, which is rather unique to our PDP bill, is that it also talks about wrongful gain which somebody else has got because they have accessed your data without your consent or illegally or outside the purview of this law, right? So if you look at the breaches, the remedies, etc., I actually see PDP to be a rather creative piece of legislation wherein it gives it's totally based on checks and balances, right? No single party has been over empowered, no single party has been over penalized under this, and a lot is gonna come in as and when the adjudicating authority or the regulator under this is gonna come up with their guidance, their notifications, their code, where they will basically be interacting with us and coming up with more and more, be it in form of educating or further telling what else has to be done.
Right.
So that's very interesting. What I would like to see is, I mean, I think that's going to be through precedence, but something that I'm curious about in the application is whether, now that this particular bill also recognize an intangible right in your data, will we expect injunctions in the form of John Doe orders under this bill if there is a breach?
Right.
That's something that even I'm curious about, and maybe we'll see as it comes.
Right. Minal ma'am, would you like to add to that?
Just one point I would like to add. There's this one piece of information, that I am very excited about, that was added to the PDP, which was the whole sandbox concept.
Right.
And the reason I'm a big fan of the sandbox concept is because, in practicality, if there is any artificial intelligence or any deep technology, that has to be tested, the sample size of the test really matters. Now, the sample size of the test is 5 to 10 people. Let's face it, a larger applicability cannot be determined. You need a sample size which is big enough that you can actually, have results that will be similar to what you are trying to achieve. Now, what the sandbox does,
I think the same thing we're looking at right now is during the vaccines and how they are being approved. The higher point of if the vaccines are effective depends on how many people they were tested on.
Yes. So what the sandbox concept really does is, it takes into account people who are educated about it enough and who are willing to, participate in that test. So they know it's a sandbox, they know it's a test, they know what information will be taken, what information will not be taken, will it be artificial intelligence or data mining. But at the end of the day, everyone knows that they are part of a test product, and it's not going to apply to the bigger market or masses at large. Now, what that does is it gives a time period to not only to companies to test it, but also to keep on rectifying it. And in case there are issues, the sandbox also provides that comfort and that cushion, that because people knew that this was a test. They were somewhere or the other already made aware that there might be a backlash. If there is a backlash, what is the extent of it? And if there is an extent, then how it is to be determined or taken care of in the future. Now, if you see the PDP bill, it gives you a time period from say 12 months to a maximum of 3 years to have this sandbox in place. And I think, as Vinati said, that it's a very specific, separate piece of legislation which has been designed separately and has all the checks and balances. The sandbox exactly that. The sandbox recognizes the fact that it is a market that is growing. There are many unknowns. And how are those unknowns to be tackled? They will be tackled through the sandbox mechanism, which gives companies space, a safe space to test, to grow. And once that tests have succeeded, they've grown, then they can actually put it to market. And I also personally feel that the time period of 12 months to 3 years is very good, because not everything can be done on a fast track basis. Some things take time to give results. And the whole sandbox mechanism provides that space for companies to grow, or companies that want to experiment or that want to take a chance at something new. So I think that it does not at one way restrict creativity and growth, but it just gives them a safe space to sort of experiment on and then go beyond and above.
So, very interesting piece of insight here that the PDP is trying to probably strike a good balance between looking after the interests of the masses, as in with respect to the actual implementation of the privacy of their data, while at the same time trying to provide a safe space, like ma'am, you said, to the companies also and businesses to actually experiment and grow, so that the interests of neither get harmed while favoring one over the other. So that's a good balance that they are trying to strike here, and I'm fairly certain that this is a this is going to probably be a very popular thing that the other may also pick up in their respective jurisdictions. But while the PDP is striving hard to strike a balance between the interests of the two, do you think that the bill in its current form is adequate in safeguarding the interests as well? So it's not just allowing the companies to grow, but the other end, when the data is actually supposed to be stored properly from the point of its inception, the collection, processing, storage, deletion, in all of those aspects, do you think the PDP is doing a good job already?
So, India has always been called sort of this parental country which likes to take care of its citizens in a very fatherly fashion, and the laws are also drafted accordingly. And I definitely
Right.
think that
Concept of parents patriot.
yeah, I mean, there are definitely points where they've gone above and beyond in relation to you compare it to the GDPR of data processing to keep the directors liable in companies as far as penalty goes, in addition to fines. But I also think it's one of the most balanced pieces of legislation I've seen in a long time. And also because, the fashion in which the legislation has always followed has always been a bit overprotective, or always has been, a bit overarching. And that nature of the law will not go away. And personally, I prefer that, because I feel that if there are enough steps and balances in place, then there's always this space allowed, for one case scenarios to say that, okay, this does not apply to you. Maybe you can be exempted. But
Right.
to in advance allow everyone to do something and then find the defaulters, that is also a way which is difficult, definitely.
Right.
So I'm quite happy with the fact that the law is there to look out for its citizen, which is what law is supposed to do.
Right.
And it's being a little stringent is okay than being too lenient. That's my philosophy. So I personally quite prefer the PDP.
Nice. That's interesting. That's a good insight and a good personal note there. Vinti ma'am, moving on to you. Once the PDP does get implemented, and probably in its current format, we don't know if the bill is going to be revised. Do you see this affecting multinational corporations, companies that have headquarters probably in other jurisdictions and also operate out of India, or even otherwise, if Indian companies also operate out of other companies? Do you also see this affecting foreign investments, FDI, all of that in probably a negative way?
Yeah,
You weren't
sorry.
you weren't audible in that one split second.
Yeah. So I don't think that it's going to impact in a negative way, but it's definitely going to change the way it works. Every time there's a new law, there's obviously an adjustment phase. There's going to be some time to just see and watch how the regulators are interpreting the law. And to me, the legislation looks like an enabling legislation, but it is going to depend on the interpretation on how the regulators are going to actually implement it. As long as it is substance over form, I think we are good, right? So now to your question about how it's going to impact the MNCs or the FDIs, etc. So I think one very important thing that we need to understand about this is that when does it impact, when does a legislation like this actually impacts a business in a negative way, right?
Yes.
This only I think I earlier told you that there are three ways your data is being collected online. One is through a direct consent, which is taken from you. Now, I'm not going to get into the format in which the consent is being taken, whether that's the disclosures are enough or not, but let's say it is being taken
In a compliant way
from you on a consent mechanism. Second is, which is I think the most dangerous one, is you do not know that the data is being taken from you. There are partner websites, there are cookies running behind on your phones and laptops, and they are monitoring your activity throughout, right? This is the most dangerous kinds, and this is generally done when your business model involves certain monetization of your data, which is where the numbers are going to matter to you, right? So I'm not talking about the criminal aspect of it, that whether your financial data was compromised and you were you were a victim of phishing scam or something like that. I'm talking about data which is being you don't even know where it's going, you don't even know that you're giving out that data. Okay, that's the most dangerous one. And the third one is by acquisition of somebody who already has your data. So now one thing with information is that there is zero cost of actually disseminating it, right? And that is why this bill imposes such hefty penalties, that there is no zero cost of disseminating it now.
Yes.
Coming back to your question, in category 2, do you see any sort of FDI investments where this kind of a model is going to be really used? Right? If you do not see such an eventuality, actually there is no negative way that it's going to impact. Now, there are two ways where you can actually use the data. One is by direct consent, as we spoke about, and second is if it's an anonymized way. And where anonymized data is used is where you are probably creating data statistics, where you are doing benchmarking and those kind of industries, like a typically consulting kind of industries. As long as they do not identify this data to belong to you, they can continue with their surveys, their research, their studying of market trends, etc. So putting this in perspective now, I think the answer is clear. It does not really impact it in a negative way, but it's obviously going to change the way we're going to look at compliances going forward.
Right. Yes, Minal ma'am, I think you wanted to say something.
No, nothing. Please.
Oh, I thought you probably raised your hand. But Meenu ma'am, I'd like you to speak about this a little bit, because I think the audience is also curious to know what are the penal consequences for non-compliance of the PDP? Because Vinti ma'am also touched upon the topic, and the audience is asking us these questions. Would you like to go over this a little bit? Just give a couple of pointers, probably.
Sure. So as Vinci rightly said, there's hefty penalty, and see, we have to understand one thing. It is still a bill. It's still a bill. It's not a law. So while we can sit here and discuss the penalty as much as we want, we don't know if that tomorrow that penalty is actually going to be implemented as a law or not.
Correct.
So let's keep in mind that what penalty we are discussing today is penalty that has been proposed in the bill. Yes, there are heavy fines and penalty that has been put in place, as Vinati said. It's simply because there's no cost in data dissemination, and it is very difficult to control where is it going, how is it going, and exactly how it can track an individual or how it can make an impact. So, and imposing penal, penalties in fines has been the most accepted format because it hits companies' balance sheets at the end of the day, right? It's something that is very out there, especially if you're a listed company, the shareholders will know. And it impacts the goodwill of the company also to a certain extent. So penal
Right.
penalty, definitely penalties there. But in addition to that, they have also taken down into consideration that a company is not governed by itself, right? There are directors behind it that govern the company and take decisions on their behalf to decide if a transaction which is, let's say, considered not to be valid in the eyes of law, and they're still going forward with that transaction, then it technically means that there's some people behind it that who are taking control of that transaction, who decided that okay, this step should happen, and this void in law or this illegality can be done. So to penalize the people who are involved, obviously they have also taken into account directors' involvement. And if a director is involved, then also they have tried to sort of put the penalty on them as a criminal liability of fraud. But obviously it exceeds ordinary situations. It will only be applicable in the extreme and rarest and rare of cases.
Right.
A lot of comments have been taken on this point, that considering GDPR only provides for a monetary penalty, why is it that the PDP in India suggests that the directors should also be held responsible? So while I understand the negative comments and considering the laws are similar, they are being implemented at the same time or being discussed at the same time at least, the comparison is definitely there. And yes, holding a director liable is obviously detrimental also to the company's growth. And there are also, multiple complications involved as to who actually took that decision. Was the director informed or not? Because let's face it, in a company, the director will also, give a lot of responsibility to its other team members. A director cannot do everything itself. So yes, while there's a comparison, the nature of penalty in law has not changed. If we see the Indian law has been a fan of monetary penalty, followed by extreme cases holding the director liable. We can see it in the Companies Act,
Exactly.
the IPC. Exactly. The same way it has been included in the PDP as well. So from an Indian legal point of view, it's nothing different. It's nothing surprising. But when compared to the GDPR, it might seem to be a little excessive.
Right. And how is the same being done in other jurisdictions, Vinti ma'am? For example, Bangkok.
Consequences. But what we need to understand, and in context of PDP bill specifically, is that it actually classifies what kind of breach has happened. And based on that, so like I said, that it appears to be as an enabling legislation. Like I understand it's in the bill format right now.
Right.
It appears to be an enabling legislation. But it also classifies what kind of breach there is, and based on that it gives you penalty, based on that it gives you a remedy, and based on that it really defines what will the quantum of penalty and whether it's gonna be imprisonment as well or not. But having said that, there is one thing which I think is gonna be always kept in sight while interpreting this bill, is that a lot of times these breaches actually happen because your hackers are always much ahead of time, right?
Right.
Your security systems, even though you may have employed the best of the security systems possible, right? You have taken all the steps that you are supposed to do to mitigate that kind of a risk, but there is still a risk of a hacker getting in, and there is still a risk of your the whatever data that you are storing to be compromised, right? So one of the things which I see in the bill is that it requires you to also store it in an encrypted format, right? So it's not like something that's on platter, and the moment the system is compromised, the person can actually get access to all the information, which is how it's different from GDPR, because GDPR makes you store all the data in exactly the way it is,
Okay.
right? So that is one difference between GDPR and PDP.
PDP.
Uh, and again, like I said, that something that we will probably see as a part of case precedents, is as part of further notifications, guidance, etc., from the regulation is from the regulators, is how we will deal with these kind of situations where data has been compromised, but it's a no fault kind of a basis, right? So you may have a legitimate purpose to collect data, you may have a legitimate reason, or you have stored it, you may have all the data privacy related policies and safeguards in check, and yet there is a breach. So how
Right.
do you provide a remedy to a person who is actually victimized of this kind of a data theft when there has not been a fault at any side?
Right. But in light of what you said, in fact, do you see that moving forward, do you see this also giving rise to a lot more businesses and companies who are just in the business of storing their clients' data? So, for example, I open up a company tomorrow and I have to collect data for something else, but it is not my preliminary job to collect and store data. So, in case I outsource it to another company whose main job is just to do this, do you see these kinds of relationships expanding exponentially moving forward? And do you also see that the liability may also get outsourced to them simultaneously?
I can see this kind of business models coming up going forward, because obviously this is a very technical field, right? Not all the fiduciary may have to access and process data, may have this kind of technology available
Tech.
to them, right? So it's
Right.
going to be a very specialized field. So yes, I understand that that's correct, but at the same time, the moment you outsource it, it actually becomes a data processor under law, and then the data processor cannot further subcontract or uh, uh, sort of have another processor to do it. So there is only one level of data processor which is allowed under this particular law. So
Uh,
whenever I am getting somebody to help me out with that, I will have to keep in mind that that is the only data processor that I'm allowed to know. If there is any further need of data processing, I will not be able to do that.
That's interesting. Okay. So, but I trust our legal fraternity to be very, very creative in their ways and figure out a way to still go ahead and do that. In the meantime, I'll circle back to you, Minal ma'am, and touch upon the
Yes,
point that
please.
you just mentioned briefly at the very beginning. It's about educating the masses about their digital rights. So we can go on and on and on and talk about data privacy and protection and how the PDP and the GDPR envision to safeguard all of it. But what good is it if the people themselves don't know the kind of rights that they have? So do you think that the governments, and not just in India, this is across the globe, should also start investing in educating the people about their digital rights?
So it's an expense for the government, and it will be
Yes,
taken out of our tax money if the government is educating the masses about it. So
correct.
that's a much, much bigger question. So I would not touch upon the fact that the government should educate the masses and how
Uh-huh.
much exactly they should go about it. Also, we should understand that ignorance of law is not an excuse as per
Yes.
the common law jurisdiction that we live in. Somewhere or the other, I feel that education is most important, definitely. because we live in a day and age where there is a difference between a country that is so fast. You know, we have fiber optics in most of our cities. We have the best internet available, but there are still places in our very own country where, you know, electricity is available for a limited period of time. We have to be very practical about what is the education level of the country, what is the understanding that they are going to get. Because if someone is not educated enough to understand basic communication skills beyond a particular manner, it is very difficult to sit and, you know, give them education about how data will work on the internet. It will probably be a wasted effort, because I don't think it will be something they'll be able to understand. So what I really think is that we need to identify who is it that we are educating, and where is it that, you know, we are trying to pass that education to. Because at the end of the day, the person who is using a particular platform, they may be, you know, used to using a platform, but using a platform is very different from knowing how the platform works and what all details are they taking from you.
Correct.
Is the customer able to read what is written? Do they understand the meaning between giving a yes and a no? And most of the cases, what happens is, if I click on a no, I'm not able to proceed forward. Be it a game, be it a website, be it a social networking community or anything like that. So is it by force that I'm giving that consent? Because if no is the option and by no I cannot proceed forward, then by default, either I leave it or I take it as what I'm getting it. So education will have a matter if, first of all, we are given a choice to proceed on a particular platform without sharing whatever data we want, or sort of limit it, you know, to the way we want it. If I take an example, is on our Android phones, you know, how we can control notifications in a particular day, particular app, and we have access to, you know, microphone or camera, what apps can use all that. These are very new things. Where are these things coming from? These things are coming from the very law that we are discussing. But at the same time, it's an option given to us. It's not like if I don't give access to my camera, I cannot use Facebook. I can still use the app. But does it apply to all the information, all the applications, all the websites that are out there? Do I still have the authority to go forward and limit restrictions, limit the access I'm giving to? Or is it that once I decide that I do not want to give them access, I'm told that the door is shut and you can leave? So it's a question which has multiple considerations in point. What is the option we are given? Who is exercising the option? Then the education, I think, also will need to be customized accordingly.
That makes a lot of sense. But tell me if this makes sense to you. So just the way the RBI and the SEBI in India have passed on education to investment companies, which we popularly call as investor education, right? Do you see that probably data regulators in India would also pass on the liability to the companies, say, who are collecting the data, that you will not just collect the data, but you will also start educating the masses about the kind of rights that they have? That might be one of the ways for the government to cut on costs, but it will be creative.
It's not just about cost. I also think that this is a liability which should be on the companies, because if the company is targeting the data, it's also targeting the customer it wants to reach. Right? Every company that out there today wants to focus on a particular segment of people who will buy their product. Right? So they, any which ways, undertake this exercise where they find the market that they're looking for. So if they're finding the market that they're looking for, then they are actually in the right place to get that consent.
Right.
And we have to remember that government is a regulatory authority. The executive authorities are very different. They are like the police force and etc., etc. But we can't expect to mix the role of a legislator and an executor and then say, you know, that, okay, the government is probably not doing this or the company is probably not doing it. It is to understand who is in the correct place and at the correct time to actually get that information out there.
Makes
And
sense.
in this particular matter, if the company is any which way is looking out there for its
Uh-huh.
market, and it has an end goal to actually send its data and to actually get monetary, money out of it, make money out of it. So at the end of the day, there's a business plan that exists in place, right? So if that business plan has already taken care of X and Y points, then educating a customer is just a part of that process.
Okay. Vinti ma'am, you have been on the other side. You worked with companies, and in fact, an IT company also. Do you look at this the same way as Minal ma'am pointed out? Do you see the companies will also be just as accepting about this entire discussion the same way?
Companies may be accepting, but I do have a difference of opinion with regards to where the onus of educating masses lies. Because one thing that we have to understand is that if there is a monetary benefit associated uh, to the company, it may not really discharge the educational part of it, which the bill requires in a neutral manner, right? So you want your masses to be informed. You don't want them to be customized, right? So that's why we have to differentiate again. If it is companies' employees, yes, it's going to be absolutely the responsibility of companies to let them know how their data is being used and all the other parts that we spoke about regarding the education part of it. But if it is the
Right.
customer, actually making company responsible for educating its customers may not be the best idea.
All right, that's an interesting insight coming in from that side of the world. Before we wrap up, we have a couple of interesting questions coming in from the audience. So Mithila asks, is the classification of personal data, sensitive personal data, and critical data better, or should it have been low, medium, or high risk data? I think this is in light of how it has been classified in the PDP.
Well, I don't think it's the nomenclature which matters. I think it's the that particular data classification denotes, which is important. So if it is biometrics, well, obviously it is extremely high risk data. Now, whether you call it sensitive data, you call it high risk data, you call it critical data, I don't think it's material.
Okay, so nomenclature is the only difference, but how it is being covered, you think is squarely similar.
There are a few loose ends. Like, you talk about genetic data, you talk about biometric data, which pretty
Mhm.
takes away entire identity of a person, right?
Right.
Compared to something like, an email address or just the user history. So you
Mhm.
can really compare the two. But
Okay.
obviously, if there is a genetic data, if there is biometrics which is involved, like fingerprint scanning, your eye scans, your retina scans, etc., etc., then I believe sensitive data is the correct classification to it. They
Okay.
obviously be dealt with differently. You cannot really mix and merge it with something like, how much do I earn monthly, and as compared to what my fingerprint or what my genetics is made up of. So you can't really put them at the same level, and you have to have that kind of a differentiation.
Makes a lot of sense. Meenal ma'am, your thoughts on this?
I'm pretty, similar on the same page as Nati, because we have this big interpretation clause in most of our contracts which says headings do not matter; they are just there for references, which is very true here. How
Correct.
you call it does not matter at the end of the day. What matters is what is it inside that you're dealing with. And there's a very simple example in the PDP between 2018 and 2019 that has changed.
Mhm.
And the thing was passwords. Should passwords be considered as sensitive data, or should they be considered as critical data? Because
Uh-huh.
as long as you need a password to log into the email, you also need a password to log into your net banking to transfer money. So it
Correct.
doesn't matter if you call it X or Y. At the end of the day, if it is something critical, it will remain critical.
Makes sense. Another question that we have is, how has the PDP bill affected gaming apps like, say, PUBG, for example, or how will it affect them?
Do you want to take this, Vinati, first? Or
No, I'm gonna claim technical ignorance for PUBG.
Would you like to go ahead with this one, Minal?
See, I think PUBG has a lot of issues. It's not limited to PDP. It's also related to how the game was being, promoting aggression and
Right.
how it was being addictive. Now, here, yes, probably you can put disclaimers and this and that. However, as far as the game having subscribers collecting information, yes, PDP will apply. How much will it affect gaming apps like PUBG? It will only matter when, honestly, PDP will be enforced and there will be probably better laws also governing gamings. At this stage, I think considering the focus on apps like PUBG has been more in line with, aggression or, games coming from China and all that have been issues with data or even the trade agreement. There are multiple aspects here. So putting it just on PDP, I feel, is sort of looking at 1/3 of the picture.
Right. Okay. One of the leading news agencies of India have asked this question recently, something that Sahil has pointed out to us. How does the PDP bill propose to regulate data transfer? I think this is across jurisdictions.
Yeah. So as far as the PDP bill proposes to regulate data transfer is concerned, I think before this conversation, Vinati has already covered that. So I would love if Vinati would want to complete it because you've already covered this before.
So it's not a very small topic actually, because data transfer will. If you go to the basics, you'll first have to collect data.
Yes.
To put in for processing, or so processing part of it is where your data transfer may also come in, right? So that's the first place. Second place that we spoke about is data localization, where your data can actually be there on a foreign server, or where your data has to be there in India itself, right? So now there are jurisdictional issues involved with that. And what I believe, and this is just my thought, though we need to really see how this entire bill and all these issues are sorted out. So how what I feel is that currently the bill already regulates the second level of your data. So first level is the data going from your data principal to your data fiduciary, and the second level is from your data fiduciary to your data processor, and that is where the bill allows it to go. The bill does not allow it to go any further from the data processor. Right now, where your data processor is going to be, that's not really clarified in the bill. It's not necessary that the data processor will always be in India. So that's where your jurisdictional issues will come into place.
Yes.
So, to my mind, the way this will have to be tackled is that data fiduciaries will have to enter into a contractual agreement with data processor with all the relevant laws, and you have to necessarily have an arbitration clause in that, because most of the countries are signatory to the New York Convention, and that makes it enforceable against the data processor also. So where
Right.
it comes to India, maybe the data fiduciary will have the primary responsibility, but they can be mirrored through indemnities and by incorporating appropriate arbitration clauses.
Right. Thank you for that. Just the last question we will entertain for the day. There are a number of them, but this one by Mithila, she asks, and this is a fairly simple question: will the PDP also cover offline data? Example, say data stored in registers manually, or is it
Yes.
only going to cover digital data?
No. So the short answer is yes, it covers offline data and any sort of data processing that is done, any collection of data, any processing of data, everything is covered. Whether you do it offline, you do it online, you do it manually, it doesn't matter.
Right. I hope, Mitra, you got your answer from that. Thank you so much, Vinati ma'am and Meenal ma'am, for joining us today. Any parting thoughts, Vinati ma'am, before we wrap up the session?
Thank you so much, Rishwin and Meenal. It was an absolute pleasure to be a part of this discussion, and you were a lovely host. And thank you so much, Meenal. You made this entire discussion so much more interesting. Thank you.
It's really nice having this discussion. Thank you so much. And Rishan, again, thank you so much for being there. Really nice having you again.
All thanks goes to both Vinti ma'am and Meenal ma'am. You have been very easy people to be hosting, and the topic again, I think it's of mutual interest to all of us. So we didn't even realize how time flew by, and we've been speaking for over an hour and a half now. I think before the audience starts wanting more out of their weekend, let's wrap up this session. Thank you so much, both Vinti ma'am and Meenal ma'am. This has been a very healthy discussion. We have a number of takeaways from this, and I'm sure the audience has gotten a lot more clarity on the PDP bill. On behalf of Lawyered, I would like to officially thank you, Vinti ma'am, for taking out the time from your busy schedule, all the way from Bangkok, in fact, for joining us here today. Likewise, for you, Meenal ma'am, thank you so much for joining us today and sharing your thoughts and giving us insights. Likewise, I would also like to thank Lawyered for having organized this session today and giving the audience such a nice platform to hear the thoughts of the dignitaries today. Thank you so much, everybody. I hope you have a great weekend ahead. Thanks a lot, ma'am, for joining us.
Thanks.